Good morning, Ms. Lee.
Good morning, Your Honors. Deborah Krupp from the Committee for Public Counsel Services on behalf of Mr. White. There are two issues in this case, only one of which was addressed by the appeals court, and that's the issue that I would address first, and that has to do with the insufficiency of the evidence. The Commonwealth was obliged in this case to prove that the defendant was in possession of a gun that was found in the air vent of the car wash.
Can I interrupt you?
Sure.
And you've probably thought about this, and I may be wrong, but I didn't see in the appeals court 128 opinion, and I thought there was testimony to this effect that the woman, I think her name's McLaughlin or something like that,
Alice McLaughlin,
who saw the shootout at the car wash or heard it, observed the defendant tucking a handgun or taking it out, I can't remember which, into his jacket.
Waistband, yeah.
Waistband.
To his
waistband.
And he was wearing a distinctive jacket that permitted him to be identified. Is that correct? Was there that kind of testimony?
The testimony from Ms. McLaughlin was that she said that she saw somebody who she later identified as the defendant put a gun into his waistband. But the reason why that is insufficient is because there was no evidence which tied the object that she says this man put into his waistband
wait a second.
with the actual gun that was found in the air vent.
When he was arrested or stopped or whatever it was he wearing that jacket that she said
She identified the jacket that he was wearing, yes.
as the same as the one who had the gun?
She identified that, but there's no evidence that...
And he didn't have the handgun on him when he was arrested?
That's correct.
Isn't it logically followed that he put it in the vent?
No, Your Honor, it doesn't logically follow.
Well, when he was stopped, he was coming out of the hallway where the gun was found.
Right. Had gun, seen by her with gun, coming out of hallway without gun, gun in vent.
Found in hallway.
Well, Your Honor, I think there are a couple of problems. One is that Ms. McLaughlin never identified the gun. There was nothing that she testified about what the gun looked like, and she never said that the gun from the vent was the same object that she saw in...
We don't require perfection.
No, we don't require perfection, but we do require evidence that an object is, in fact, an operable firearm. And there is, the Commonwealth couldn't rely upon her mere observance.
Somebody was shooting guns there that were operable because she heard all kinds of guns going off.
There were a minimum of 5 guns at the scene. There was no evidence that the gun from the air vent, first of all, was even put there on that day, but there was no evidence that that gun was fired at the scene.
Well, I thought there was evidence actually of the opposite. Isn't that so? That none of the bullets or casings found were connected to that gun?
Correct. Right. There was all sorts of ballistic evidence which was, retrieved by the police.
2 guns retrieved, this one and another one, neither of which ballistically was connected to the shells and casings they found.
Right. And the shells and casings they found permitted them to conclude that there were at least 3 other guns which were fired at the scene, and there were all sorts of people at the scene who were completely unaccounted for, and then there's a large space of time that was completely
But in a very
unaccounted
short space of time, this person with this Fuju jacket, or whatever it is.
Fubu.
Well,
Fabu.
a distinctive jacket.
Actually, there's no
Whatever
evidence
do
it
you
was
say
a
it?
distinctive
Well,
jacket.
it seemed to say something
Obviously, we're
that
saying
meant
it
a
wrong.
lot
How
to
do
other
you say
people.
How do you say it?
Is that a trade name for a jacket?
Well, actually, there's no evidence about that,
the letters
Your
on
Honor.
the jacket?
The evidence at trial was that there was a black jacket with the letters FB on it, and that some people referred to that as a FUBU jacket.
Okay,
but there
so-
was no evidence about whether or not this was unique, or
Well, people
how
can use their
distinctive it
common
was.
sense. I mean, a jacket with FB on it.
You're not
It's
really,
not every
you're not
day.
going off on the fact that of her identification of this individual. Your point is that the gun she saw or testified she saw is the same one that was found in the vent. That's right?
I think there are 2 points, Your Honor. I mean, the second argument does have to go with identification. But with respect to the argument on insufficiency of the evidence, our argument is that the Commonwealth never tied up the gun that she supposedly saw from 25 feet away for a few seconds with the gun that was found in the air vent. And in
But
fact, there's
if she sees the woman across the street saw the person who turned out to be the defendant put a gun in his waistband, she and other people testified that that person went around to the back of the car wash.
no, she testified
The
that she
other
saw
people,
that person
the-
go towards the back of the laundromat, and then she couldn't see him
Right,
anymore.
but she saw him go towards the back, and I think the actual victim said that somebody else saw him go around the back, I thought.
No, there was testimony that a witness who the Commonwealth, there were two eyewitnesses to the actual shooting that the Commonwealth chose not to call. One of them was the first person who stopped the police officer, and he said something about people who were firing guns went behind the car wash, but we don't exactly know when that was. And we do know that there were all kinds of people that disappeared, like the people from the abandoned white
Well, we know
Ford
that
Windstar.
your client went there. We know it because he was
yes.
caught by the police coming out that very door.
Yes, he went there, but the only thing I would object to about Your Honor's characterization is that he was caught by the police, because what he did was
Yeah, he came out the door and
walked
the-
out the door and
and the
walked
police were-
immediately up to the police officer and
all right.
said,
Who was there
we
looking
were
for-
just shot at.
Yeah, who was
And he
there
was
looking
not-
for the people that had fled to the back of the car?
And the other thing I would just note, because of the way that the facts were elicited in the Commonwealth's brief, is they also were not the first people at the back of the car wash. I mean, the first thing that happens is the officer finds some unknown, unidentified man that apparently...
Crouching down.
No, not that man.
Not that
There's,
man.
No, there's the crouching down man who doesn't
said-
go to the back. Who doesn't go to the back of the car wash? But when Officer Guzman, who's the first one who arrives, goes to the back of the car wash, the first thing he does is he has a conversation with an unidentified man who's at the back of the car wash. We don't have any idea who that person is, except we know it's not the defendant or the defendant's cousin or Ralph Anderson.
All right.
So you're
But the
saying there
defendant
were
comes
other-
out the back door with the person he was seen with on the street. He now no longer has the gun. Well, how much time passed?
Comes
A
out the
minute?
front door.
No, he comes out the
Back-
back.
back-
I'm sorry.
How much time has
he
passed?
walks through the hallway. We don't know. We know that
A minute, 2 minutes?
We don't know the answer to that
Within
question.
15 minutes, didn't she?
She says it's 15 to 30 minutes between the time when she sees the two men near the laundromat,
She tells the police those
and
are the guys.
she identifies them for the police. She
Later
says that
on,
it's
when they
15
come- when
to
they're
15
brought
to
back.
30 minutes later.
Is there any evidence concerning the time period between when she said she saw the two men run away and when Officer Guzman, when they approached Officer Guzman out of that back door?
I don't believe there is any testimony that links those things up. I mean, we know when it is that the officer talks to the man who's crouching, Jose, I'm sorry, I forgot his last name, and we know that after he talks to Jose that he immediately goes to the back of the car wash. And then we have her testimony, but those two things aren't actually linked up
And
as far as I can recall.
I take it that we have to conclude at least one of two things. One, that at some point he disposed of the gun. The jury can credit the testimony of the witness who said she saw, and she was quite specific, tucking a gun into a waistband. And I assume, I haven't looked at the testimony, but I assume that that witness was cross-examined. You sure it was a gun, so on and so forth.
Excuse me, that she was shown the gun?
No, she was cross-examined. Are you
Examined.
sure
She
it was a
was-
gun, She was
Well,
cross-examined on what she saw.
She was definitely cross-examined, but I think, I mean, I
Any
do
case,
think
so-
that there's this issue that, even if the jury accepts, I mean, clearly the
We have to
evidence
look at
and
it
the
that way.
best, in the best light to the Commonwealth is that what she saw was a gun, but not that was a
Oh, no, I understand.
firearm within the, within.
No, I
The
understand.
gun may be a firearm,
But-
had to have been disposed of somewhere within a
So
very
we
short
either
period of
have to
time.
accept that the gun was disposed of someplace else. That's possible, and that, I think, goes to the import of Justice Botsford's question about what evidence is there about where this person could have been. And the second is that there were other people in that hallway.
Many, potentially.
Was there evidence that there were other people in the hallway or in the area of the car wash? I don't recall from the briefs, but no, I don't remember any brief saying that
That's
there
why
were
I
other
said
people in the
hallway.
hallway. They say there were other people in the area and of the car
Well,
wash.
I think that what it's fair to say that the evidence showed is that there was no restriction of who was going in that hallway. That when the police came, the police set up their tape, but the tape that they set up didn't block off the hallway. The tape just went along Washington Street and Brooklyn Road and
Yeah, but
Rossmore Road.
To
And
get
we-
over the rail, it doesn't have to be proof beyond a reasonable doubt, and even that doesn't have to eliminate every possibility. And all there has to be is the evidence in light most favorable to the Commonwealth would support.
Well, what it has to
Conviction beyond a
support,
reasonable doubt.
but the jury cannot make a decision based
Based on
upon
speculation.
conjecture, and that's really what's happening here. Because there are a couple of questions. One is nobody has any idea when that gun was put in the air vent. I mean, for all we know, the gun could have been in the air vent for a month. There's just no evidence about that at all. There's no reason to believe that
Except
anybody
that
would have
also
noticed it.
the panel covering that vent just happened to be out of place.
Was there a photograph of that vent? In other words, how noticeable it was? Because I know you talk about how Officer Guzman walked through there and didn't seem to notice anything the first time. Was there a photograph in evidence?
There are photographs and evidence. I don't believe that there's a photograph which shows what it was like before the police ever moved it. I do know that there's evidence that nobody noticed that there was anything awry about this until after they found the gun, and it was only after they shone, the flashlight in that they then noticed that this grate was out a little bit. So there was no reason to believe that employees walking through there on a regular basis for, who knows how long, for the previous week, would have ever noticed that there was anything awry about that air vent. And in terms of the people, I mean, we know that in the area there were all sorts of employees. We know that, all kinds of people fled. We know that there was identification.
But that's not the point. It seems to me that the jury is being asked to infer that the defendant was seen because the defendant was seen with a gun in his waistband, disappeared behind a building, and was seen walking through a hallway, stopped at the end of the hallway with no gun in his waistband, with nothing in his waistband. The gun had to have been taken out of his waistband and placed someplace.
But he wasn't seen walking through the hallway.
Coming out.
He was seen
Coming
coming out of the
the
hallway.
door.
And the jury is being asked to infer that he is the one that he took the gun out of his waistband and put it up into the air vent. Is that an unreasonable inference to draw?
Well, for all the reasons that I've been talking about and for what I cited in my brief, I think it is unreasonable in this case.
Was
where
there
we have-
evidence that area right around the car wash, the narrow area where the defendant was seen, and then when he was seen coming out of the hallway, was that area searched? Was there evidence that the police say we searched the area around the car wash for weapons?
Yeah, they
Okay, and they didn't find one.
Well, they found another weapon in Brooksby, right on the road.
Okay, but I'm talking about the defendant was only in the area of that hallway and.
Actually, we don't know that, Your Honor. What
Well,
we
he
know,
was seen by this woman.
the time is not linked up. The time's not linked
Yeah,
up,
but
so
you see-
we don't really know that.
Can we move to the second question, which interests me quite a bit?
Sure.
And that is, why hasn't your client effectively waived this by not raising the objection at the end of the judge's charge, waived the issue of mistaken identification?
Because,
Go ahead.
I'm sorry, I didn't want to cut you off.
No, go ahead.
Okay. Well, I don't think that he waived it because he brought it to the judge's attention both in a written request and because it was discussed and because the judge was very clear that the judge was not going to give the charge.
But how do we know that? But then how do we know that your client didn't change his strategy and during the instructions decided the way things are going and the way the judge is instructing, I don't want that instruction?
Wasn't
How
the
do we
charge
know
conference
that?
at the end of the case?
Yes.
No, the charge. Yes, but I'm
Yes.
saying during the instructions, how do we know that your client
Your Honor,
didn't change his
Well,
strategy?
I
What's
guess
his
the
thinking?
short answer to that is this court hasn't required that. What this court has required defense counsel to do is to make it very clear to the judge what instructions the judge the client wants. And when the trial judge says, I'm not giving that instruction, then
It's preserved.
then
and
the
you don't
issue
have
is
to object.
preserved.
I agree. This is a little different, and I want to know whether you think it makes a difference. Here, as to this instruction, the judge says, well, I'm not going to use your words. So it sort of leaves it open. I'm not going to use your words. And then he doesn't give the instruction. He doesn't give the mistaken identification instruction. He gets the normal instruction on eyewitness identification. At that point, don't you think this is a little different where, Judge, you not only didn't use my words, you actually didn't give the substance of it? Doesn't he say that? I'm not going to use your words?
Well, what he says is, well, I'm not going to give it in the terms that you've typed it up on number 6, mistaken identification and identification witness certainty. And I think that if you go back to the actual request, that was separate from, mistaken identity was number 6,
Right.
split mistaken identity, which was different from the, sort of Rodriguez charge. My interpretation of what the judge said was, I'm not giving it. And counsel said that she wanted it, and the judge said, no, I'm not going to give it, and there wasn't going to be anything served by asking yet again. I mean, the point had been made, and the trial judge made the trial judge's decision.
Thank you, Ms. Cliff.
Thank you.
Ms. Lee?
Good morning. May it please the Court. My name is Macy Lee. I'm an Assistant District Attorney, and I represent the Commonwealth in this matter. I will address the first issue that's before the Court, and that is whether sufficient evidence supports the defendant's conviction for possession of a firearm. And
Ms. Lee, it would be helpful to me if you essentially just addressed the appeals court, because as far as I can see, the appeals court essentially gave 3 reasons.
yes,
1, there was no evidence suggesting that the defendant was the only person who had access to the hallway. 2, or that the gun was placed in the vent after the reported gunfire, or after the eyewitness had observed the defendant. That 2A and 2B. And 3, insufficient evidence that what the eyewitness saw was actually a firearm as defined under the statute. So those are the 3 pieces that the appeals court says are missing. And how do we get over that?
I get over that by beginning saying that the appeals court was clearly wrong.
No, I understand that.
Because there is a bundle of ample evidence that supports the conviction. What the appeals court neglected to note in its opinion is that there is an enormous sequence of events that happened in a very small period of time that led to the jury's logical,
I understand that, but
reasonable
you
conclusion.
don't question any one of those 3 points.
Well, those are possibilities that clearly could exist in this
No,
particular
but
case.
Mrs. McLaughlin said she saw a gun.
Correct.
Did she retract that testimony at all?
She never retracted that
So how can the
testimony.
appeals court say, as if I'm paraphrasing now, there was insufficient evidence of what she saw that it could be a gun? If she testified, the jury's permitted to believe that she saw a gun.
Essentially, that's correct, John. And what
And
the
how
appeal-
far away was she?
She
25
was
feet?
25 feet. It
And
was
25 feet
broad
isn't
daylight.
very far. It's probably to where that gentleman is sitting back there, maybe closer. So, gee whiz, you can certainly see a gun from that distance.
absolutely.
Is the appeals court incorrect to conclude that it's the Commonwealth's burden to show that it was a gun capable of discharging ammunition?
And there's evidence by
No, is the answer to that yes?
yes. Well, there was evidence. Well,
Yeah.
there was yes. There's
So
evidence.
what essentially the appeals court is saying is, gun, yes, but no evidence that was a gun that was capable of discharging ammunition.
That's why you have to link it up to one of the guns that was
Right,
found, right?
which was found irrelevant. Essentially, what the appeals court did was substituted its judgment of its weight, of the weight and credibility of the evidence of that of the jury, which
Can you
is
help us out with the timing here?
the timing. Yes, Justice Buffett. Essentially, what happened was this happened at 4 o'clock. Alice McLaughlin was standing on the corner. She had just gotten out of her car. She was waiting at the corner of Washington, I believe, Rosmore, waiting for a friend to pick her up. At around 4 o'clock, she heard
4 in the afternoon.
Yes, 4 o'clock in the afternoon. This was May 21st, 2001, broad daylight, sunny out, dry weather, from what I can gather from the evidence. She suddenly hears firecracker-type sounds, and in her testimony, she said it sounded like a shootout at the OK Corral. She immediately looks over at the car wash. She sees people ducking, running for cover. She sees Hakeem White, who is the defendant's cousin, approach the corner of the car wash. I think it's Washington Rosmore. He's wearing a light blue shirt, his hair styled in cornrows. Immediately after Hakeem White comes out, she then notices the defendant, who's wearing a black jacket with the words FUBU in white lettering, come out, tucking a gun in his waistband. She then sees both men turn around and go towards the rear of the car wash. Right at that point, Officer Guzman, as well as with his partner, Officer Angelo Hernandez, was driving by on Washington
How do
Street.
you know it's right at that point?
Because what had happened, the testimony of Officer Guzman indicates that as he and his partner was driving on Washington, they noticed a man crouched down near, I think, one of the bays of the car wash, very nervous, desperately flagging down the car. They stop. I guess it was the the car wash attendant told the police officers that there was just a shooting, a shootout, that the two suspects went towards the rear of the car wash.
Why would the two suspects go back into the car wash?
Based on the evidence here, perhaps to conceal the weapon, which is what the Commonwealth
The
maintains.
police are out front.
Yes.
They've run to the back.
Yes.
Any evidence, is there any barricade there, any high fence?
No.
So they could have just kept going?
My understanding is that there's a doorway that leads to a hallway. That
No, I'm
connects.
talking about, her testimony
Yes.
is that they run around the building to the back.
Yes, they approached the back.
And the cops are there by that time?
Well, the
Yes.
cops are in the front.
So they run
The police
around
officer-
because,
The police officers are in the front.
Yes.
are they in a marked cruiser?
Wait,
Yes.
you don't, other than putting these two things together, you don't have any, she doesn't say, as I saw them running, I saw the cops come, right?
Well, she didn't know. What she says is that she then waits for police, and then I go back to Alice McLaughlin's testimony, where she testifies that she then waited for police officers. She saw police officers come, approach the area. Then she crosses the street, and then stands there looking for police officers. And then she
Saw them approach, and when was that in relation to when she saw the two men run?
she did not testify that they ran. She says they just went towards the back. I don't think that there's any.
Well, when did she see the police officers in connection with
She
when
did not testify to that. But she said that as soon as police officers arrived at the scene, she then crossed the street. And then when she saw the police officer, she immediately gave a description of the man she saw tucking the firearm in his waistband, which is the person wearing a black FUBU jacket.
Isn't
And
it
then-
logical to infer that these two people saw the police coming and decided to get rid of the guns?
Absolutely.
And the
Why is it
defendant went in and-
logical? Why is it logical to infer that they come back into the place where they
Because-
know the police are
Because
about to
they
search?
had no place to go if the
Because
police
at the
are
time,
there.
there was a shootout. Apparently, there've been discharge. There's ballistic evidence indicating that there was discharge of 4 different firearms. There's a shootout.
Can I just go back
Yes.
for 1 second, Leslie? I think you started off earlier by saying that people were running away.
Yes, people were diving. According to Alice McLaughlin, people were diving for cover, crouching down, in an attempt to avoid being caught in the
And
gunfire.
running away? There were people running away?
I don't believe that there's any testimony of anyone running away. She
Are
just
there
said
any
that-
pictures of the car wash? in
Yes.
evidence? Do they show what's in the back of the car wash?
There are photographs. Photographs were admitted into evidence of concerning the car wash, the laundromat, and the hallway. And
Okay, what can you tell from the photographs what is in back of the car wash?
Not in the car wash.
But in
behind.
back of the building.
No.
There's a
Outside.
building that's a car wash. Can you see from the photographs what's outside the building?
I don't believe that there are any photographs of the rear of the car wash, just the front, inside. And then I know that there was a photograph of the hallway that contained
No, I understand,
the air
but I'm
vents.
just again trying
But
to...
isn't it logical for the jury to infer that these two people knew if they ran away, they'd be caught because the police had arrived, so they had to get rid of the guns?
Absolutely. I think based
And
on...
maybe the other fellow threw the gun away.
Absolutely.
That's his gun.
And
Did
again,
they
but there's
search
no
was
testimony...
there evidence that they searched the area for guns?
Yes, there is no evidence that, based on Alex McLaughlin's testimony, that Hakeem White ever had a firearm on him. Perhaps he did, but there's no evidence.
What
to that
happened
fact.
to the cousin?
To Hakeem White? I don't know.
They couldn't link the
Does
thrown
he
away
come
gun
back
to
into
him.
the hallway?
He does. He comes out of the hallway exit with the defendant in this case, and that's where Austin.
And how do we
Guzman-
know that he didn't put the gun there?
I'm sorry.
How do we know he didn't put the gun there?
That possibly does exist, but again, based on Alex McLaughlin's testimony,
No, I understand that.
the only person
But-
who had a gun was the
So there are
defendant.
at least 2 people that she identifies as having been closely associated with the shooting, both of whom were in the hallway.
Yes.
Can I move you to the second point here?
Yes.
Do you agree with me that if the defendant had requested the misidentification instruction, it should have been given in this case?
No, I do not agree with you on that. For many reasons. First of all, the theory of the case, the defendant's case, was never focused on mistaken identity. When the court reads both the opening and the closing arguments of the defendant, there's been no mention whatsoever of mistaken identity. Second, Alice McLaughlin never testified at trial that the defendant who was sitting in the courtroom was the defendant she saw at the car wash. There was no identification made by her, made by the officers, yes, but not by Ms. McLaughlin at trial. There was never an issue of mistaken identity. In fact,
Well, wait, could the officer's identification have been mistaken?
yes, and there was no challenge by the defense on cross-examination of the accuracy.
But the key to this case is McLaughlin saying, I saw that man, the defendant who I picked out that day, put a gun in his belt. That's the only thing possibly linking the defendant to that gun. And that's based on an identification. He was the man. I pointed him out to the police officer, right?
Right. But there was never a challenge that it was someone else, that it wasn't the defendant.
Doesn't
that
have
was
to be
You don't need to have that.
It doesn't have to be a challenge that it was someone else.
Well, again, but there was identification. A mistaken identification was never made. It was not. It was not a theory
Honest,
of
but
the
but
case.
the instruction of an honest but mistaken identification was requested.
Yes.
And you're saying because identification was not an issue in this case, it didn't have to be given. It wasn't Presley or any of the other cases that say it has to be given.
No, and then also based on circumstances in this case and based on cases from this particular court, this identification was made in broad daylight, 25 feet away. There have been cases where...
That doesn't seem to matter.
Well, there are cases that have held from this court that where an identification was made 1,000 feet away.
Yeah, when
That
they knew the
mistaken-
person. When they knew the person. This is my neighbor. I know this person.
But there's another case where it's 25 feet away where the person did not know that
Which
person.
case is that?
That case is... Commonwealth versus Burns.
Commonwealth
I'm
versus-
sorry, that's not by this court, that's by the appeals court.
25 feet away, and that was enough. It wasn't the fact that there was a prior relationship between the
There was no
people?
prior relationship between that one. The other case is Commonwealth versus Grace, and that was 100 feet away, again, during daylight, unobstructed view. I believe that the witness did not know the defendant.
Commonwealth versus Burns. Let's see. You have here the defendant clearly eschewed a mistaken identification theory. All right, that's what you say is similar here. There was no request for a misidentification instruction at all in that case. Right? So there was no defense of mistaken identification and no request for an instruction in that case. Isn't that different?
Yes, I mean, different because there was a request here. But again, based on the facts in this case...
And the witness had known the defendant for several years.
In Grace. Or
In Burns.
In Burns.
This is that's completely different than this case.
Well, but here, there was never a challenge of Alice McLaughlin's identification.
Well,
because
maybe
there was
that's your strongest point.
Right, but there was no identification
I
made
have a
by her.
question.
Yes.
The judge said that because the identification made in court was done at the request of the defense attorney, I didn't quite understand the relevance of that.
I agree with you on that, Justice Crown, because there, again, the identification was made by Officer Guzman, Detective Waggett, and never by Ms. McLaughlin.
Well, you
So
need, but there are
was
two identifications. You need
Yes.
both of them, don't you?
Yes, yes, and those, yes, in terms of the identification was made by the law enforcement officers, but not by the eyewitness herself. who
Wait a
saw-
second. No, McLaughlin identified the defendant to the police.
Yes, yes, yes.
And then the police just testified, this is the man that McLaughlin identified.
Right, but there was never a challenge at trial that there was a possibility that Ms. McLaughlin, mistakenly identified. She was very clear, very strong in her testimony, without any doubt in her mind.
Clear and strong is not the
Right.
standard.
But there was no confusion in her testimony that there was, there was
That's not
possibly
the
someone
standard.
else.
Okay, but you're saying it was not an issue contested at trial.
That's right. And in closing argument, there was not even a sentence mentioned that there was a possible mistaken identification. The defense attorney, defendant's attorney at trial only attacked the credibility of the witnesses.
Well,
Well,
the
but not,
credibility,
but
the
never.
credibility that she saw a gun, the credibility, I mean, of course, credibility is what this is all about.
No, but she did not attack Ms. McLaughlin's credibility of seeing a gun or ability to identify the defendant at the scene.
What was the basis of the cross-examination?
Her basis was, if I can recall correctly, was how she saw the defendant coming out of the car wash, and why she stayed at the scene. And at one point, Alice McLaughlin said, well, I just thought, what a gall they had to stay at the scene after seeing the defendant tuck a gun in his waistband. So why she, that she was caught up in the excitement of it. But she never challenged her on cross-examination on her ability to correctly identify the defendant at the scene.
Thank you, Ms. Lee.
Thank you.